All rise. The Court of Appeals, Division 1 is now in session.
Please be seated. Thank you for being here. We are here in our case 1CA CV140647, and forgive me if I mispronounce it, Roosh versus Browning. Each side will have 20 minutes to argue. You have a clock at the podium to watch your time. Appellant, you have 20 minutes, and you can reserve as much of that as you like for a rebuttal, but it's up to you to watch your time. We're recording the argument both in audio and video, and in a couple of days or so you should be able to see the argument on YouTube. Because we're recording it, please identify yourself and your client when you begin your argument. We've conferenced the case, we've read the briefs and the records, so we're familiar with the argument. So when you begin, just launch right into what you want to tell us. Counsel, you may begin.
Thank you. May it please the court, Jason Kelly for the plaintiff appellant. As I was looking over this and reviewing the papers getting ready, I realized that perhaps the biggest area of confusion and maybe an area of concern was the procedural posture of what exactly happened in this lawsuit. So I'm going to back up again. My clients originally filed this lawsuit for breach of contract and a request for judicial dissolution of the partnership for the reasons stated in the complaint. In this lawsuit, there was no claim for an ejectment or an eviction or anything else. My clients prayed for a money judgment, dissolution of the partnership, liquidation of its assets. Now, this lawsuit was proceeding in Yuma County Superior Court. My client, the partnership, the family limited partnership, the landlord, asked the defendant to start paying rent again. And again is an important point because he had paid rent in the past.
And why had he paid rent the first time?
Why had he paid rent the first time? Well, Your Honor, I don't know that that's part of this record. I have taken his deposition, but I don't know that it's part of this record. I can, understood.
That's okay.
But
that it was only for like 3 months or something?
Correct.
And again, only according to what's in the record, was it preceded by a demand for rent?
I don't know if that's in the record or not.
Okay.
So as this lawsuit's progressing, there was a demand to pay rent. There was no rent paid. There was a demand to vacate. He did not vacate. So we filed a separate action for forcible entry and detainer in justice court. On the day we were set to go have the forcible entry and detainer action, the defendant obtained the ex parte TRO in this lawsuit. Now, what's confusing to some extent is that it's not relief prayed for in any of the pleadings in this lawsuit. And I suppose I should have made an objection at the time, but we were willing to go with substance over form at that point.
So all we're dealing with here today is whether the preliminary injunction was proper or not.
Correct.
But I think what you're explaining is that technically the case that's in front of us never involved the ejectment or FED aspect of this, is that?
Correct. And if you look at the prayer for the complaint in this lawsuit, there's no request for an eviction or an ejectment. It was only when another suit was filed in justice court that the defendant went to get a TRO in this case. And then there was a subsequent hearing within 10 days per the rule.
At any rate, there doesn't seem, however confusing all that is, there doesn't seem to be any disagreement amongst us as to what issues we're here about, right?
Well, I think the clarification is important because at least in my mind, the crux of Appellee's argument, and it's on pages 14 and 15 of the answering brief, was the appellant's cases would be relevant if this was a case for an eviction. And they try to say we asked for some sort of ejectment in this case, which are legally different. My point being, the order, both the ex parte TRO and the preliminary injunction, enjoin my client from initiating or prosecuting any eviction actions. So when we look at the substance of this case, the question is the appellee entitled to an injunction stopping a landlord from filing an eviction action against a commercial client who hasn't paid rent?
I take it that he can raise whatever defenses he has or any arguments he has in the FED action?
In the FED action per ARS 12-1177A, the FED action only permits inquiry into the right to possess and not the right to title. And the defense raised, and the trial judge said, you have a substantial success of likelihood of the merits on a theory of executed license. So the question is, for this court I believe, is executed license an inquiry into title? I submit it is, and I submit that's why we need reversal. I mean, once that's established, all the prongs of the preliminary injunction test fail because it's against the public policy as stated by the Arizona legislature. There's no substantial likelihood of defending on an inquiry into title, and the balance of hardships as set forth, again by the Arizona legislature is commercial landlords need to be able to evict people quickly and not wait around for 2 or 3 months, or 2 or 3 years, pending all these inquiries into title.
Excuse me, but how is the alleged facts surrounding the existence or non-existence of a license have anything to do with title?
A license is the right to do something which is otherwise illegal.
The right to possess, to be in possession.
The right to be on the property.
All right. How is
It's
that,
not a
how
possessor
does that have
interest.
anything to do with title? It has the right to do with possession, doesn't it?
Well, the executed license defense is that once you've permitted improvements to land, you're stopped from kicking out the licensee, and the licensee has an equitable right to possession.
Okay, I'm still not following how that has anything to do with title to the property.
Because the equitable right to possession is assignable. It's title. So in the cases...
Well, but and please correct any misunderstanding I have. He's saying he has the right to stay there, but he's not saying that he has any particular ownership in the property, is he?
Yes. An executed license, this is Keystone Copper versus Miller, 63 Arizona 544 at, I think I miswrote this here, I think it's 551. Quote, an executed license is, quote, an equitable right capable of being assigned and which may not be discarded or revoked by the owner of the premises. A right able to be assigned is a right to the title. If executed license is a defense in forcible and entry and detainer actions, and we can go on for years litigating this, it defeats the purpose of forcible entry and detainer. And I guess the court disagrees with me on whether it's a right to title. Bigger picture, is this something that should stop the forcible entry and detainer action? I submit no. Because we need to have a right to evict people. That's what the statutes say.
Right,
Well,
but
but
if our task is to determine whether there is or is not an executed license, doesn't that end our job here? I mean, the FED is really not in front of us, right?
The ability to bring it is in front of you. My client is enjoined from evicting.
So you're saying that even if we were to say there is an executed license, that you can still kick him out in the FED?
Well, I think the injunction should be lifted to permit the prosecution of that action.
I'm still having trouble seeing how anything about the FED is really in front of us when the question seems to be executed license.
The FED is in front because the order, I'm at page 3 of the order, lines 13 to 15, enjoined my client from filing the action.
Right, so you have a position which is there's no executed license, therefore the injunction was incorrect. But you have a fallback position that even if there was an executed license, that we should say the FED should go forward?
Right, because first of all, if you look at the other 4 prongs, the public policy is to have a resolution to the possessory interest. We should be able to get a quick resolution to that.
And I'm not going to dissuade you from making whatever argument you want to make, but you probably would want to get to talking to us about whether there was an executed license here or not. Because I think you want to talk about that, don't you?
Well, I'm going to submit that. I mean, that's one of the 4 prongs. I'm starting, frankly, with 4 because of the public policy to get a quick resolution to these issues. I'm also going to submit that there's not irreparable injury for eviction of a commercial tenant. We cited the Ninth Circuit case, and I think the record is devoid of any evidence of irreparable injury that cannot be fixed by money damages. And frankly, I think those are the 2 biggest of the 4 prongs requiring a reversal and a dissolution of the injunction. As to the executed license, the only cases we've cited is where people have made substantial improvements to land. Now, what we've got here is some tenant improvements to a commercial building.
And that's a question I had about the state of the record. What do we know about the nature of the tenant improvements? Is all we know that the improvements have been made? Do we know what they are?
There was testimony by Mr. Browning that he made, quote unquote, substantial improvements.
Yeah, but there's no evidence about what those substantial improvements are.
I don't believe so.
Okay.
I'm sure I'll be corrected if I'm wrong, but I don't believe so.
Wasn't the testimony that he moved the dental office from one end of the building to the other and created a new dental suite?
Essentially, which he'd have to do in any dental suite he moved into anywhere in the country, I suppose. Dentists have to do tenant improvements in order to make it work. Restaurant owners have to add stoves.
Was there any testimony about the permanency of any such improvements?
I don't know. I'm not familiar with that part of the record.
And the improvements were within the building. They were not to the land itself.
He claims it was infrastructure. There might be tie-ins to public stuff that might be under the land, but I'm guessing. I'm trying to answer your question, but I'm kind of
That's fine.
hypothesizing. And the Goldie's case, the Ninth Circuit case we cited, touches on this idea that just because you make some improvements to the building doesn't block the right to evict someone. Anytime a tenant makes an improvement to Goldie's involved a laundry room in an apartment building. The vendor improved the apartment building with plumbing and other things to make the laundry work. And I think there was like a profit sharing agreement. And when they went to move the laundry company, the vendor, off the premises, that question was brought before the Ninth Circuit. And it said, if we let every tenant who makes improvements to property stop people from filing FED actions, you can never file an FED action, which would be contrary to the point of these statutes.
Do we know what kind of improvement support an executed license and those improvements that do not?
The only cases we have are the cases from the 50s and 60s, 40s. The Keystone Copper case, and there's the Gillespie, I believe it is, case. And they're talking about, I know in Gillespie they're talking about waterways and huge drainage structures. In the 1945 case, the name's escaping me again, the copper mining case, it was something to the effect of cattle ranching and taking care of these animals and herding them and putting structures on the land that improve the value of the land itself. There's not a case, as far as I can tell, where you get an executed license for improving a building. And I'd submit that improving a commercial building is even more far removed, given the realities of tenants making improvements to suit the space to their business.
So your argument is, whatever the nature of the improvements to this commercial building, it just could never be enough.
I would submit it'd be the rare case indeed where a tenant doing something to a commercial building would obtain an executed license.
Okay.
I'm not going to come up here and say there should be a holding black letter, because frankly those facts aren't before us.
Sure.
And I do want to point out, I want to reserve some time, but I do want to point out our alternate request would be that the $500 bond is simply inadequate. The bond to be, if the preliminary injunction is going to issue and it's going to be upheld on appeal, the bond is there to cover my client's potential damages. Rent on this, they're only asking for $1,500 a month, which we think is below market, but we're sticking to it. You know, if this litigation goes on for another 2 or 3 years, $500 bond is meaningless. So I don't want to lose sight of that alternate argument that if the court denies the appeal as to the preliminary injunction, I think the setting of the bond at 1 week's rent is an abuse of discretion.
Thank you, counsel. Counsel?
May it please the court, my name is Megan Scott, appearing on behalf of appellee Dr. James Browning. Sort of to briefly go over the general issues in front of the court, with all due respect to appellants, there's no procedural due process issue in this case. The appellants were given notice and an opportunity to be heard. And the order appealed is from an order to show cause hearing where appellants were to show cause why the preliminary injunction should not be entered. When that hearing was held, the appellants did not present any evidence of their own. They did not present any testimony. The only evidence that was presented was that of the appellee.
What does the record show about the nature of the improvements to the property?
So the improvements that were made to the property, the appellee spent over $300,000 improving this new suite. So the
first of all, is that in the record?
Yes, I'm looking at the transcript from the preliminary injunction hearing, and the appellee testifies that what he thought was initially going to be a $60,000 remodel turned into almost $300,000 as a gut it and start all over. And so the appellee explained that a dental practice is like a hospital. You have to have extra plumbing, wiring, vacuum lines, compressed air, water, and all of that is sort of put into the walls and into the floors. So it is more complex than just, putting in some water and leaving it at that. And then he also upgraded his digital technology, which required a lot of extra conduit and extra cables in order to do that. So his testimony at the preliminary injunction hearing went through just how involved those improvements were. And he did testify to the cost of what those improvements were.
And those are permanent improvements?
Sorry?
Those are permanent improvements?
Yes, I mean, they're put inside the walls and under the floors, and then everything is boarded up. I'm sure that someone could go in and tear down the walls and rip it all out, but for the most part, they're permanent. It wouldn't make sense to do that.
The reason I asked that question is if there was a new tenant who was a dentist who cannot use those things, they would come in and rip all that out.
Or I think some of it could probably stay in place. I know that in the suite that Apelli used before, which was further down in the building, they did end up leasing it to another dentist, and so a dentist did come in and use that suite, and so the same could be done with this new one that he's improved. But I think at the same time, a lot of those things could be left as is. Maybe your next tenant is not a dentist, but maybe the tenant after that is a dentist or a doctor. Or
Isn't that the point? In order to support an executed license, the improvements have to be permanent in the sense of permanently benefiting the real property. I mean, it's not enough to say, well, we built them in stone so they can't be removed. The permanence has to attach to a beneficial aspect of the real property ownership. Isn't that right?
Yes, I mean, the law on the executed license, at least the case law that we reviewed and included in our brief, states that when a licensee expends large sums of money in making the improvement and it's made without opposition by the licensor, the license becomes executed and as such is irrevocable.
Right, but for example, in the Keystone Copper case, the buildings not only they benefited the property clearly because the corporation itself used them. The property owner used them and got benefit from the addition of the buildings to their real property. And then in the vending machine case, they made the point that transitory improvements or improvements that don't benefit the property itself won't support the executed license theory.
Well, I think the building that we're talking about was built in, I believe, 1967, and was significantly outdated at that point when those improvements were made. So as far as bringing a benefit to the building, I would say that if anything, the benefit of just improving that suite alone, the other suites have been left outdated and very few of them have been updated. His has been updated with, not only the things that are needed for a medical practice or his dentist practice, but everything in it was improved and updated, and the new wiring could be used for someone who needs that sort of thing.
But the only way that could result in permanent benefit to the property itself is in the fortuitous event that another dentist wants to move in there, right?
I guess, but I guess my argument would be, what is the benefit of ripping out all of your walls and putting them back up and ripping out your floor and doing all of that? There is permanence in that. In order to remove all of it, you would have to pretty much completely destruct your suite.
I think I'm accepting that in a way it's kind of permanent. It's just that it doesn't permanently benefit the property in any way that I can see the record demonstrates.
Is there evidence in the record that the improvements increase the value of the property?
There's not proof in the records, no, that have been before the court. So with regard to the appellant mentioned that rent had been paid at a certain time, and in Dr. Browning's testimony at the preliminary injunction hearing, that issue was addressed. The rent checks that were paid by Apelli's ex-wife, who was asked for money by one of the appellants. She wrote the checks, and those were later designated as rent. But there was no intent behind those to be paying rent. It was sort of the money was asked for and the checks were written, but there really was no intent by the appellee to pay rent. And as soon as the appellee found out about that, those checks stopped. And that's why those checks are only for a period of a few months.
And how is that relevant to whether there's an executed license or not?
Because I feel like the appellants have tried to make the argument that because he paid rent, that changed the nature of his license and what was going on, to the point where they're trying to say that, you know, maybe there for sure wasn't a license and maybe there also wasn't an executed license because they requested that he pay rent and he paid rent. But when those checks were paid, the intent was not to pay rent. The ex-wife didn't know what those checks were for. And so to say that that somehow weakens appellee's license or executed license to the property, you know, is inaccurate given the intent behind the checks that were paid. And with regard to the distinction between maybe the eviction actions and the action that's before the court, this wasn't just one eviction action. I mean, I think the appellee, when it was time and he filed his application for a temporary restraining order, we were on the third eviction action. You know, so this wasn't something where this was just the first one and there wasn't any sort of inconvenience from it. There had been three. The other two had failed and they were before the court again on it. And that is why my client filed the application for the temporary restraining order.
But your argument that he can't be evicted is based on the theory that he has an executed license.
Yes, Your Honor. So with the executed license, it's not about title. An executed license is about possession. And so if you look at the case law with regard to defenses for a special detainer action, it states that any legal defense to the plaintiff's claim of right of immediate possession is available to the defendant. An executed license is a clear defense, given that it has to do with appellee's possessory interest. It's a valid defense to the special eviction actions that were occurring. And because they had been multiple, it got to the point where the temporary restraining order seemed necessary in order to sort of stop all of these eviction actions from happening, with the argument, of course, that the executed license would keep them from evicting him from the property anyway. And so they should be enjoined from continuing to file those actions and try to remove him from the property.
If your client is successful in demonstrating an executed license, that guarantees him the right to possess it, but does that affect the ownership interest in the building?
I mean, I think that it limits them to the point that he has a right to be there and use that space. This case is a little strange in that he does have sort of a separate interest and title because he's part of the partnership or the family business that owns it. So it's a little bit different in that it's not a normal case. So he does have some title interest, and that interest that he does have in title is enough to keep them from selling the business or doing anything like that. But with regard to the executed license, it really just gives him the right to be present and use the premises and not be removed by his landlords, which in this case is his family. So there's kind of two separate issues. He's capable from a title standpoint and being an owner in the partnership from letting them sell the building. But then with his executed license, they're sort of prevented from evicting him like they would a regular tenant. The appellants also argue that my client fails to prove irreparable injury, and states that, you know, because this is a commercial place, that, you know, his only damages are maybe that he has to pay for a new building or pay rent somewhere else. But whenever you have some sort of medical practice, in this case it's a dental practice, there's additional harms that come to that, which were put not only in our application for the temporary restraining order, but also on the record at the hearing for the the preliminary injunction. In addition to losing obviously all the money that he put into the property, he would have to expend more if he were to have to move, and maybe there would be money to pay rent. But in addition to that, there becomes the issue of patient care. And when you're moving from one building to the other and your practice is ceasing business, it affects your ability to care for your patients. You may lose patients in between those moves. And it sort of affects the goodwill of his business. So it's not just a monetary injury there. There's these additional things that have to do with his ability to care for his patients, keeping his patients, and being able to have a place to provide that care. So in addition to the monetary damages, which are maybe more clear, there are also these goodwill and patient care issues that help prove the irreparable harm in this case. With regard to the bond issue, which in this case, just like with the preliminary injunction, is reviewed for abuse of discretion, Rule 65E of the Arizona Rules of Civil Procedure states that the bond should be set in such sum as the court deems proper. And so it's left in the court's discretion. At the time of the setting of the bond, in front of the court, the facts were that appellee was not required to pay rent because of his executed license. There was no signed written agreement that he was to pay rent. And so based on the facts that were before the court, the $500 was a sufficient bond, or the court found that that was a sufficient bond. And the facts supported the same thing. The appellants were given an opportunity to argue that that wasn't a sufficient amount at the preliminary injunction hearing, but no evidence was presented to the contrary. And so for that reason, there was no abuse of discretion in setting the bond at $500, and that decision should be upheld. To quickly go through the remaining elements of the preliminary injunction, the strong likelihood of success at trial on the merits had to do with the court finding that there was an executed license in that case. If you were to go forward with trial with his executed license, he would have been successful. The possibility of irreparable injury, not remedial by damages. Like I said, yes, there are monetary damages, but if you couple those with the goodwill of his practice and patient care, and losing those patients and not being able to provide the care that they needed was enough to show the irreparable injury. And with regard to a balance of hardships, appellee showed the strong likelihood of success on the merits. He showed that the irreparable harm existed. The preliminary injunction, if granted, didn't change appellant's previous or current situation or deprive the appellants of any property right interests that they had before. And they provided no evidence to the contrary at the hearing that the injunction was putting them in a situation that was different than what they were already in. And really the only person who would have been affected had it not been entered would have been the appellee. And so with all of those factors, the trial court was right in finding that the balance weighed in appellee's favor. With regard to public policy, it also favors appellee's injunction. An executed license is a legally recognized interest that should be respected and protected. He proved the general factors of that and why it should be granted or why he would be found to have one. He made those significant repairs and improvements without objection. And so now when it's financially inconvenient to them, they shouldn't be allowed to revoke that executed license. So given all of the facts of this case, he presented within his application and then also at the hearing on the preliminary injunction, he showed that he met all four elements of the preliminary injunction being granted. And as I said, the appellants didn't present anything that the judge would have been able to consider that would be contrary to that. And so the trial court did not abuse its discretion with regard to granting the preliminary injunction either. One of the other issues that was brought up by the appellants in their opening brief was an issue with regard to procedural due process. And they argued that their procedural due process rights were violated. In this case, the appellants were given notice of the temporary restraining hearing. They were given 2 hours notice. They were given a copy of the application. Appellants counsel did show up for the hearing time as set, and it's admitted to the same in the opening brief and in their opposition. The court just simply did not hear oral argument from either side. He read the application and granted the temporary restraining order and then set the motion for order to show cause hearing. The appellant was then given an opportunity to draft an opposition and filed that opposition. And then the preliminary injunction order to show cause hearing was held. They were given another opportunity to present their arguments and their objections. And they just simply didn't bring any evidence or testimony to that hearing. So they were given and received notice reasonably calculated to apprise the parties, and they were afforded several opportunities to present their objections. And so with regard to procedural due process, there was no violation here, and the trial court did not err.
Thank you, counsel.
Thank you.
Rebuttal?
Thank you. Jason Kelly again. On the issue of executed license, the Keystone Copper case at page 556 of the Arizona report starts talking about what an executed license is. I'm not going to spend much time on that. Whether it's, I think executed license a title. Maybe it is, maybe it isn't. If I'm wrong, big picture. Why can't we try that in the FED action? The answer, that's a rhetorical question. FED actions are to be quick resolutions so commercial landlords can get non-paying tenants out without 2 to 3 years of litigation. Even if executed license is not an inquiry into title, why should that not be a question asked at the FED action in justice court? Why does there need to be an injunction stopping my client from litigating that question? The answer, there's no valid reason. The discussion of irreparable harm is not supported by anything on the record other than the conclusory statements of the defendant, who doesn't want to kick it out because he wants to keep staying there rent-free. Balancing the hardships, it's beyond comprehension how a commercial landlord not receiving money while someone's occupying its space is not a hardship on that landlord. And again, public policy, the statutes say this is to be quick. We just want the opportunity to go file the FED action. That's all we're really asking for. And I submit there's not been a good reason presented to this court why we can't go forward with an FED against a commercial tenant. And I'll talk about this due process quickly. I understand to some extent the TRO is moot, to a large extent the TRO is moot. The actions taken by the trial court do not comply with the rule. And once we got this inertia going, it was costly and difficult, as you can see, to unwind. And the only reason I included it in the briefs is because I submit the rules not being followed in many courts, and perhaps some guidance from this panel would explain it to the trial judges. Unless there's any questions, I'm done.
Thank you, counsel. We appreciate the argument. We'll take this matter under advisement and we'll issue a ruling in due course. We're going to stay on the bench while the next case comes. We stand in temporary recess. Thank you.
That's the way you whack the hammer. I was doing a probation violation as a prosecutor one time. This investigator was testifying for the defendant, and he was lying there, laying on his ass. And it was getting close to the end. And there was Dick Mango, was the judge. Gets up, that clock strikes 12. He leaned over, took down the gavel, and he whacked it right on the corner of the bench, right next to the witness's ear. And the witness just about jumped out. I thought, that's what that hammer's for.
That's funny.
That was a very strange argument. The appellant spent about 2 minutes talking about executed. Even though we told him he had not been talking about that.
Thank you. Sure. Just give me a wave. Good morning. We're here today in our case 1 CACV 140580 Yamamoto versus Cooksmore and Feltus. Each side will have 20 minutes to present your argument. Appellant, you may reserve any portion of that time for rebuttal, but it's up to you to keep track of your time or not. We have the clock on the podium for that purpose. We are recording the argument today both in audio and video, so when you address the court, please identify yourself and your client. The argument should be up on YouTube in a few days if you want to watch how well you did. We've read the briefs and the record. We've conferenced the case, so we're familiar with the arguments and the facts. So when you come to the podium, just launch into what you think is important for us to hear. Counsel, you may begin.
Good morning. If it may please the court, it's Antonio Dominguez on behalf of the appellant, David Yamamoto. And we have 4 issues that I want to address with the court. One is the savings statute. The second is the 46456 statute. The third is the rule on attorney's fees. I just drew a blank. And the last one is the post-judgment order or judgment that was entered in this matter. Let me go into the savings statute right away. And I submit that this is this is a case of first impression in that my review of the savings statute, all the other cases that are decided, there's never been an issue that the first action was actually filed timely. Go back and look at it, they're all been filed, but they're dismissed for several different reasons. Lack of prosecution, abatement, some other reason. This case is the first time where somebody is challenging that the initial filing was not timely. And that's based on Judge Portley's memorandum decision in a older case, which I'll make reference to as the probate case. In this matter, which is an interpleader action, we filed a motion for summary judgment saying that initially they filed a declaratory judgment action, and we filed a motion for summary judgment saying it was not timely. And the trial court came back in its response to the first motion for summary judgment and said that it saw Miyuki's filing, filing in August of 2010 as a counterclaim. But the trial court then states that it does acknowledge that David Yamamoto had already dismissed out his petition for guardianship conservatorship. The trial court then states that this wrinkle takes the court into unexplored areas of the savings statute. We submit that it's not a wrinkle, that it was a fatal mistake by the court. The court then states that the dismissal was of a technical nature, and thus that he thought that he should find in favor of the savings statute applying. We then filed a second motion for a summary judgment based on the count of 46456, and the trial court came back once again and said in its ruling that the Court of Appeals memorandum decision does not go as far as Mr. Yamamoto would take it. Judge Portley held that the probate court did not have jurisdiction to decide any motions after the case was dismissed. And then the trial court, in quote, says those actions are a nullity. Then the quote says those actions refer to the court's ruling on the motion, not to the filing of the motion. The filing of an action in a court which lacks jurisdiction is recognizable under the savings statute in cites Templar versus Zelli. We then file a motion for reconsideration, and the trial court comes back third time and says, as this court has pointed out, the Court of Appeals held that the probate court's ruling was a nullity because of lack of jurisdiction. It did not say that the motion itself was legally non-existent. I submit that legally non-existent is the same as a nullity. I submit that a filing or filings are the same as actions. And if If it's not that, if in fact this court is going to recognize in the exception that Judge Fink, the trial court judge, found that this filing does exist, then it kind of puts everything on its head, because under Rule 41, everything is gone. It's a nullity. We point some of this language out in our brief, that a nullity is something that is legally void. Black's Law Dictionary says it's a nothing, no proceeding, nothing's taken place. And yet the trial court made this exception. I submit that he could not have made that exception. Let's have, if I could, have Judge Portley rewrite that last sentence that we've been focusing on, where Judge Portley said, as a result, the court did not have jurisdiction to decide any motions, and he's making reference to a motion to reopen. And he says a motion to reopen to file the petition. But let's just change those words from any motion to any filings. And let's just change the word from nullity to non-existent. Would that have changed the trial court's ruling? Again, I submit that these terms, these words are interchangeable and have the same legal effect, that you cannot recognize the August 2010 filing by Jeannie Yamamoto's then legal counsel. We also cited to Judge Portley's case, which was Spring versus Spring, and inside Spring versus Spring, we found the A.B. Dick Company case, which is a federal district court case, but it also gives instructive guidance that a voluntary dismissal of a suit leaves the situation, as far as the procedures therein are concerned, the same as though suit had never been brought. Again, we come to the same conclusion, that there was no filing in 2010. If there's no filing in 2010, how can the saving statute apply? The saving statute has to save something. And again, if you go back and look at all the saving statute cases, it's where plaintiff's counsel has filed an action. For some reason, it got dismissed. And based on the dismissal, one of the cases I recently read was where Judge Pendleton Gaines actually ordered the dismissal. It was refiled, and there was actions taken that went contrary to Judge Gaines' order. Court of Appeals said, no, that's a appealable order that Judge Gaines gave, and therefore you don't get the relief that you asked for. One of the other issues that I've brought up to Judge Fink was, well, nobody filed a motion to reinstate. And he said, well, my reading of the statute says there is no requirement. Yet, looking at all the case law, it does appear that there has to be some sort of request to reinstate a dismissed matter. I'll leave it to this court to determine whether or not there is a requirement. But there has to be some sort of procedural process to seek the saving statute relief. If you don't have any questions on the saving statute, I'll leave any rebuttal on saving statute, and let me move on to my argument on 46456. Let me first start that I need to apologize to this court in that in my review or preparing for oral argument, I now realize that Judge Fink may have applied the wrong standard. It appears in his ruling that he utilizes the 2009 version of 46456, yet he applies the 2009 version of 46456 to conduct that occurred in 2005. And there's a gulf of difference in the two versions. And in our argument to Judge Fink,
Excuse me, counsel, this argument wasn't raised to Judge Fink, was it?
it was argued in the motion for a new trial, and not directly, but it was in that we were citing Davis versus Slatos, that there was an exception to the trustee's conduct.
So it wasn't even really argued in the motion for your trial, it was alluded to?
I'm sorry, Your Honor.
I'm just trying to understand your point. Are you saying you cited the appropriate cases, but you didn't make the explicit argument?
That's correct, Your Honor.
And how can we consider that?
Excuse me?
Then how can we consider it?
Well, Your Honor, let me address that in that there is case law, and I always call it the ice cream case, but it's the Nestle ice cream case, where even though both parties have misapplied the law, the standard, I am duty-bound to inform the court that there is a standard that the trial court did not use. And I'll leave it to this court's discretion as to whether or not you will use the correct standard for review. I'm just saying, I'm bringing it up to the court's attention. I think I'm duty-bound to do so. I don't know if anybody had already noticed this, but I'm bringing it to the court's attention. Let me then move on to Judge Fink's findings.
Well, but what difference does the
difference between the two statutes?
Yeah.
The difference is this, Your Honor. In the 2009 version, it reads, and Judge Fink, this is his conclusion of law, the court concludes that David Yamamoto violated ARS 46456 because he was a person in a position of trust and confidence to his mother, a vulnerable adult, and he failed to use the vulnerable adult's assets solely for her benefit. That word solely for her benefit is something new in 2009, in the 2009 version. The 2003 version reads as follows. A person who is in a position of trust and confidence to an incapacitated or vulnerable adult shall act for the benefit of that person to the same extent as a trustee. Under the 2003 version, a trustee was permitted to engage in transactions with the beneficiary benefiting the trustee if the beneficiary consented and was not under any incapacity at the time of such consent. We cite to the Davis versus Slatos case, which is exactly almost the same facts that we have in our case. And in that case, they said, well, a trustee should, if a trustee is working with a vulnerable adult, should have that vulnerable adult seek out an attorney or a family friend before that vulnerable adult potentially gives property to the trustee. Here, Mrs. Yamamoto consulted with her CPA of almost 20 years, who said to her, Mrs. Yamamoto, if you're going to sell this property, you need to bifurcate it, because if not, you're going to have a $500,000 tax liability. And he advised her, there truly were some wrinkles in that she gave the property completely to David, David gave it back to her, and then she gave half of it to David, and then they sold the property, exactly the way the CPA had planned to avoid the $500,000 tax liability. Interestingly enough, Mrs. Yamamoto did receive a $500,000 tax assessment, and it's in her record, because they had not filed the tax returns correctly. So that potential is out there. But for the CPA's guidance, there's this $500,000 tax liability still sitting out there for this estate now. So that's the difference, Your Honor, between the 2003 and the 2009 version. And as a matter of fact, I guess there's now a 2013 version. But when I was looking at the 2013 version, it's not applicable here anyway. But It doesn't go to our issue here before the court. Let me briefly go to the next 2 points, and that is Rule 54G. Now, the trial court found granted attorney's fees, but if you go to the pleading or the pleadings that were filed by the appellee, they asked for attorney's fees under 12-341 initially, and then they asked for 12-341-01 attorney's fees and any other applicable statutes. And we cite to the King versus Titsworth case, which Judge Thompson was concurred in, as citing that no, if you want attorney's fees, you need to state where you're getting your attorney's fees from. It's not just in any other statute that applies. If that's the case, then let's just put that into the rule. Just say, I'm asking for attorney's fees under any applicable statute, and be done with it. I submit that was legal error by the trial court. Lastly, we have, after Judge Fink signed a final judgment, I filed a motion for a new trial, and it was denied. And then we received a motion for attorney's fees for having to defend the motion for new trial. And we submit that the court no longer had any jurisdiction. By this time, it's Judge Winton. The Judge Winton had any jurisdiction to order an additional judgment.
Counsel, that seems strange to me that you affirmatively moved for a new trial, but now you're claiming that the court didn't have jurisdiction to grant fees. Do I misunderstand the argument?
Well, I'm not sure I'm completely understanding the court.
Because it seems like heads I win, tails you lose, kind of.
No. All we're saying, Your Honor, is if they want attorney's fees later on, and if they're successful and they get an affirmation, this court, and it goes back down to the trial court, they can ask for additional attorney's fees. I don't think they could ask for attorney's fees after the final 54C judgment had been filed in Superior Court. I think that Judge Winton lost jurisdiction to make that ruling. In addition to that...
Would he have had jurisdiction to grant your motion for a new trial?
No. Anything in furtherance of the appeal is okay. I don't think that a request for attorney's fees is something that's in furtherance of the appeal.
Right, but who denied your motion for new trial?
Judge Fink.
In the first judgment?
I'm not sure, Your Honor. I believe it was after the first judgment.
We'll check that.
Yeah, I would have to.
Well, we'll check it.
Yeah, I mean, the record will reflect what it does. In addition, Judge Winton found that attorney's fees under 12-349 as a sanction for filing a motion for a new trial. And he doesn't give any findings or factual basis why he decides to sanction my client for that post-judgment procedure. I submit that that's an abuse of discretion on top of not having jurisdiction to do that. Now, and then he issues a second 54C judgment. So we have two 54C judgments, and it almost sounds like a first-year law school trick question. How many 54C judgments can you have? What did your second notice of appeal purport to appeal from? Well, it was to the second 54C judgment, Your Honor. I mean,
just to the second fee award?
Yes.
That's what the notice says?
Yes, because again, might as well be precautious. Yeah. So if it's a nullity, it's a nullity. But if it's not, at least I don't want this court to come back and say I didn't appeal that. So, Your Honor, I only have one more minute left, so I'll reserve that 1 minute.
Thank you, counsel. Counsel.
May it please the court, my name is Molly Eske. I'm representing the appellee, Kirschmar and Feltis, PLLC, as Special Administrator for the estate of Miyuki Yamamoto. As set out in our brief, the trial court's...
What does special administrator mean?
We've been appointed in a limited capacity here. It's basically to continue to prosecute this appeal in which we previously represented Mrs. Yamamoto.
Okay.
Your Honor, as set out in our brief, the trial court's decisions below have strong support in the record and should be affirmed. With my time here today, I'd like to focus on 3 reasons why the trial court ruling should be affirmed. First, the trial court properly found that David Yamamoto violated the Adult Protective Services Act by taking the funds interpleaded in this case from Miyuki in 2009. The second reason is that Miyuki's claims were timely filed and the trial court properly applied the savings statute. And third, Miyuki is entitled to recover her attorney's fees under the Adult Protective Services Act. First, I'd like to address why the trial court properly found that David violated the Adult Protective Services Act. To find a violation under the APSA, the trial court needed to make 4 findings. First, that Miyuki was a vulnerable adult in 2009 when the money was taken. Second, that David was in a position of trust and confidence with respect to Miyuki at that time. Third, that the money belonged to Miyuki in 2009. And fourth, that David used that money for his own benefit.
Yeah, can you discuss briefly the what statute applies and what difference that makes, if any?
Absolutely, Your Honor. Again, as the court's already pointed out, I don't think that was an issue that was raised below. The distinction, as I understand Mr. Dominguez to have raised it here with the court, is between whether to apply a 2003 version of the Adult Protective Services Act or a 2009 version. Here again, our claim for violation of the APSA is with respect to exploitation that occurred in 2009. The first time that the claim was raised was in 2010 in the probate court. So there's no reason why an earlier version of the statute would have applied. I haven't done a red line to compare the differences between the two, but as it was described by Mr. Dominguez, I don't think that that distinction makes a difference in this case. 2 of those elements of the 4 elements of an APSA claim, I don't think the court even has to consider here. It doesn't appear that David's contesting them. The parties have stipulated in their joint pretrial statement that David and Miyuki had joint bank accounts. That's sufficient to establish a position of trust and confidence under the Act. The parties have also stipulated that the money at issue here was moved by David from the joint bank account into a Charles Schwab account only in his name and to his lawyer's trust account. That establishes that he used the money for his benefit. There's no claim that the money was in fact used for Miyuki's benefit by David. That leaves us with 2 remaining elements of the Adult Protective Services Act: whether Miyuki was a vulnerable adult in 2009 and whether the money belonged to Miyuki in 2009. So starting with the first of those, the trial court properly found that Miyuki was a vulnerable adult in 2009. First of all, the statutory standard for a vulnerable adult is fairly low. Any person that's unable to protect herself due to physical or mental impairment qualifies as a vulnerable adult under the statute. There's substantial evidence in the record here that Miyuki was unable to protect herself due to a mental impairment. First, in November 2009, when Miyuki reported to Wells Fargo that David was taking money out of the account without her permission, Wells Fargo contacted Adult Protective Services, and Adult Protective Services immediately began an investigation. The investigator, Bill Dettelbach, then interviewed both Miyuki and David in December 2009. So we're talking about a month after the money was taken out of the account. Mr. Dettelbach testified in his deposition in this case, which was admitted into evidence at IR 110, that when he interviewed Miyuki in December 2009, she, quote, did not appear to have her full facilities, and that in his extensive experience, she did not have full capacity to defend herself. Then in January 2010, again just a couple months after the money is taken out of the Wells Fargo account, David filed a sworn verified petition in the probate court asking to become Miyuki's guardian and conservator. In that petition, David attests that Miyuki was incapacitated at that time. He also says that Miyuki had dementia that made her, quote, unable to manage her property and affairs and, quote, make or communicate responsible decisions regarding her person. Those are statements by David as to her condition just a month after he took the money out of the account. David also later admitted at trial in his trial testimony that Miyuki's condition was probably the same as early as 2005. So certainly there's substantial support for the trial court's finding that Miyuki was a vulnerable adult in 2009 and as early as 2005, based on David's own admissions. I'd like to move then to the last element of the APSA claim. The court properly found here that the money in the joint bank account in 2009 was Miyuki's money. The parties have stipulated here that the facts in the account all came from the sale of the Camelback property. That was Miyuki's longtime family home that was sold in 2005. So David has previously admitted that the money in that joint Wells Fargo account belongs to Miyuki. In his December 2009 interview with Bill Dettelbach, which has been entered into the record at Trial Exhibits 99 and 100, David told William Dettelbach, after Mr. Dettelbach questioned him about the ownership of these funds, yes, it's her money. He said that repeatedly through his interview with Mr. Dettelbach. Later in the January 2010 petition filed by David to become Miyuki's guardian, David listed a whole series of assets that belonged to Miyuki's estate. And in that list, he included the then $300,000 that was in that Wells Fargo account. David said, this is in Miyuki's estate. This money belongs to her. Despite these admissions, David has claimed at trial that the money in the joint account nonetheless belongs at least in part to him. And he makes that claim based on a gift, two different types of a gift. Either that Miyuki previously gifted him an interest in the Camelback property itself in 2003 or 2005 before the property was sold, or that Miyuki gifted him some portion of the proceeds from the Camelback property by depositing it into the joint bank account, the Wells Fargo account. But the trial court found for a few different reasons that Miyuki never gifted the Camelback property or its proceeds to David. The trial court reached that conclusion from findings that, first, David was Miyuki's de facto conservator in 2005, and also that Miyuki lacked any donative intent back in 2005. Given my limited time today, I'd like to focus on the trial court's finding that there was no donative intent in 2005. This finding by the trial court is critical. It not only establishes that the Camelback property and the proceeds belong to Miyuki and always have, but it defeats any claim that David could raise here. David's only assertion to this money is that he was gifted the money. The trial court's findings of no gift in 2005 and that Miyuki lacked donative intent at that time must be accepted on appeal unless they're clearly erroneous. So, taking a look at the law, to make a valid inter vivos gift of real property, there must be a clear, unmistakable, and unequivocal intention on the donor's part to make a gift. We know that from the O'Hare case and in remarriage of Berger. A gift will only be upheld if the donor has sufficient mental capacity to understand what's being transferred in the transaction. That's the Amato case tells us that. Here, the record contained ample evidence that Miyuki likely did not understand that the execution of a 2005 warranty deed would permanently divest her of an interest in the Camelback property. First, David's trial testimony established that this was a complex transaction. This was not an everyday, regular transaction to convey, to execute this gift tax return and also to finalize the sale of the Camelback property. And again, David's testimony at trial suggests that Miyuki was also likely suffering from dementia back in 2005 when the deed was created. Second, the record reflects two temporary transfers of the Camelback property from Miyuki to David prior to this transaction in 2005. Those transactions were in 1987 and 2003. And on both occasions, after Miyuki deeded an interest in the property to David, it was conveyed back to Miyuki within a year's time. And in other words, there's a history of transfers here of the Camelback property that don't seem to suggest a gift. Both of those transactions coincided with loans taken out on the property. This transaction was executed a month before the Camelback property was sold.
Yeah, either the is the basis for the claim, all of this activity with the causing the selling and the buying of the home, or is it just the misappropriation of the money in the Schwab account?
And I appreciate that, Your Honor, and I'd like to make that distinction. Our claim here in this case has always been both a declaratory judgment claim that the monies interpleaded belong to Miyuki, and also a claim under the Adult Protective Services Act for exploitation of Miyuki by the taking of her money in 2009.
So, although what happened in 2005 about selling the house, that's where the money comes from, but that's not that's not connected to your substantive claim.
That's correct, Your Honor. Effectively, when the property was sold back in 2005, the money then gets deposited in early 2006 into this joint bank account, and it continues to sit there in that account.
And the reason
Right.
the reason I asked is I was trying to connect what you were talking about with the claim that the prior statute applies. And I think there must be some confusion about what the basis of the exploitation is. At least as far as you're concerned, it's not the actual selling of the house, it's what happened to the money afterward.
That's exactly right, Your Honor. From our standpoint, the only reason that we're even discussing a 2005 transaction is because David has raised it as his defense in this claim, that he asserts that he has a right to some of the proceeds from the sale of the Camelback property because he was made a gift of the property back in 05 or back in 03 or back in 06 with the deposit of the money. That's the only reason why we're talking about events back at that time.
Could you comment on Mr. Dominguez's argument about the what sounded like a reason for the transfer? There was tax liability that was extinguished or deferred or pushed off of the potential estate.
Yes, absolutely. And in fact, that basis for effectuating the transfer, for executing that gift tax return, for executing this deed, we feel supports the court's finding that there was no donative intent in 2005. Roger Brown is an accountant. He was both Miyuki's accountant and David's accountant. And Roger Brown testified that he explained to Miyuki that this deed needed to be executed and this gift tax return needed to be executed a month before the property was sold to avoid capital gains tax. And there was a significant amount of testimony at trial about whether he'd correctly calculated the capital gains tax or correctly advised Miyuki in that regard. But no one disputes that Roger Brown, with the aid of David, sat down and explained to Miyuki that these documents needed to be prepared and executed to avoid tax consequences. Now, from our standpoint, that suggests that really perhaps why Miyuki executed these documents is because she had an accountant telling her, you need to shore up this paper transaction to avoid taxes. It's not to vest a permanent interest in the property to David, to gift him anything. It's because she believed this needed to be done to avoid taxes and that she'd go back to having the home, just as she had with the previous temporary transfers of the property for financial reasons. Critically, the only evidence that Miyuki intended to give the property to David came from testimony by David and by Roger Brown, both of whom are interested parties who want to see that this transaction is upheld. And the trial court specifically made a finding in its order after trial that the testimony of David and Roger Brown largely lacked credibility, and it was within the trial court's purview to make that determination after hearing the live testimony. So from the evidence in the record, it was not clearly erroneous for the trial court to have found a lack of donative intent with respect to those 2005 transactions. And for that reason, the deposit of the proceeds from the sale into a joint account also doesn't create any gift to David. It's well-established Arizona law that deposit into a joint account alone doesn't establish a gift or donative intent. There are many reasons, like convenience, that people might have joint accounts. And for that reason, the intent of the depositor in depositing those funds is what controls. We know that from the O'Hare case and also the Brown case. Here, the court has found there was no gift of the property to David in 2005. So when the property is sold, it belongs to Miyuki in whole, the money is hers in whole, and when it was deposited, even into a joint account, the money remained all hers. I'd also like to talk about why Miyuki's Adult Protective Services Act claim was timely. We've already gone through some of the dates here, which is part of the battle, but again, Miyuki's claim for exploitation under the Adult Protective Services Act stems from David's taking of the money in November 2009. And the record reflects that's when Miyuki found out the money was being taken. So Miyuki had 2 years then until November 2011 to bring a claim based on that exploitation. In August of 2010, the APSA claim is filed in the Maricopa County Probate Court. So the APSA claim was timely filed within the statute of limitations. As the court is aware, the probate court ruled in Miyuki's favor on that claim, but it went up on appeal. The Court of Appeals ultimately dismissed that action due to a lack of subject matter jurisdiction. After that holding by the Court of Appeals, Miyuki then refiles her claim in the Maricopa County Superior Court, and that's what's led to this appeal. So the real issue here is whether the savings statute allows Miyuki to refile her APSA claim in 2012. Now, Arizona's savings statute confers an automatic right to refile a claim terminated by appellate mandate for reasons other than a lack of diligence by the party within 6 months of the claim being terminated. Here, the Court of Appeals mandate was issued in June of 2012, so Miyuki had until December of 2012 to get that claim refiled in the correct court. And she did that. Miyuki filed a declaratory judgment claim in the Superior Court in October 2012 seeking return of the Camelback proceeds. Those are the same cause. There's no reason to distinguish between what was filed in 2010 and what was filed in 2012. Miyuki then later amended her complaint to add an express claim under the Adult Protective Services Act. Because all of these claims arose from the same transaction and occurrence, we get the benefit of Rule 15, taking that APSA claim back to the filing in October 2012. David contends that the savings statute can't revive the 2010 APSA claim because it was dismissed for a lack of subject matter jurisdiction. But the savings statute broadly provides that if a timely filed action is terminated in any manner at all, other than by abatement, voluntary dismissal, dismissal for lack of prosecution, or final judgment on the merits, the plaintiff has an automatic right to refile within 6 months. There's no carve-out or exclusion for dismissal based on a lack of subject matter jurisdiction. It's also consistent with the public policy behind the savings statute to allow Miyuki to refile this claim. The first claim was simply filed in the wrong court through no fault of her own, no dilatory conduct, no neglect. She didn't know that that claim couldn't be filed in the probate court, and the probate court had granted her the relief she sought. There was no need for her to file a claim elsewhere, and Miyuki had no reason to believe that the order she received from the probate court wasn't valid. And it wasn't until she got that Court of Appeals holding that said this needed to be filed in a civil court that she knew she needed to do that, and she timely refiled her claim.
You're getting close to a minute left, and there was an assertion made that you failed to seek fees under an appropriate substantive authority.
Yes. Thank you, Your Honor. I'll address that right now. We provided a supplemental case to the court, the Prendergast case, and we provided that just last week, and we think that
we know that one.
Okay. And I believe that helps to resolve the issue here. Rule 54G requires that a claim for fees be made in the pleading. We made a claim for fees under any applicable statute. I would agree the best practice would be for us to have invoked a specific statute in making that request for fees. But based on Prendergast, I don't believe that David's been surprised or prejudiced to learn that in asserting an APSA claim, we're going to seek our fees under the APSA. We'd placed David on notice that we would be seeking attorney's fees if we prevailed in this case, and that's what we've done. I'm out of time here, Your Honors.
Thank you, counsel.
Thank you very much.
Rebuttal?
Thank you, Your Honor. Antonio Dominguez once again. I want to take in reverse order what counsel just said. One of her last comments was that Miyuki, through no fault of her own, filed in the wrong court. Well, that's not true. She had filed an ex parte motion in the probate court, and the court commissioner had denied it and said, I have no jurisdiction. So she was already on notice. She had no jurisdiction. For whatever reason, she files a motion to reopen. Still doesn't have jurisdiction. So she knew that she didn't have jurisdiction. In her motion to reopen,
The lack of jurisdiction was based on David's voluntary dismissal?
correct. It's gone. The other thing that I want to point out is counsel argued that the exploitation of Miyuki occurred in 2009. Well, if that's the case, then why did Judge Fink go all the way back to 2005 to attempt to find that she was a vulnerable adult? And I submit that when Judge Fink says Miyuki Yamamoto is a vulnerable adult, that's a conclusion of law. He doesn't provide anything in the record as to why he thinks she's a vulnerable adult in 2005. He then says, oh, she doesn't have donative intent. Yet there was a recorded deed based on advice of her accountant. And
Counsel, your time is up.
Thank you.
Let you briefly conclude if you wish.
John, I think the arguments are in the file. Thank you for the time this morning.
Thank you, counsel. Thank you for your argument. We'll take this matter under advisement and we'll issue a decision in due course. We stand adjourned.